Welcome to the National American Indian Court Judges Association's Tribal Legal Advocacy Training Webinar, Tribal Law and Order Act, TLOA, Enhanced Sentencing, and Violence Against Women Act, VAWA, Special Domestic Violence Jurisdiction, Constitutional Standards for Tribal Court Judges. The National American Indian Court Judges Association, NAICJA, is a national nonprofit membership organization devoted to supporting and strengthening tribal justice systems through education, information sharing, and advocacy. NAICJA provides broad and comprehensive training and technical assistance to support tribal justice system capacity building and partners with national organizations to educate the broader legal community and public about tribal courts and judges, and builds relationships between tribal and state court judges. NAICJA is the Tribal Justice Training and Technical Assistance Provider under the Bureau of Justice Assistance, Tribal, Civil, and Criminal Legal Assistance, TLOA program, offering training and technical assistance to TLOA grantees and sub-grantee legal aid organizations. NAICJA's TLOA program seeks to increase and improve access to legal assistance in Indian country by providing training and technical assistance for the development and enhancement of tribal justice systems. Further, TLOA will assist in strengthening the capacity and the quality of indigent criminal defense services and defense strategies for tribal justice systems. NAICJA is coordinating and implementing a multi-part training series, including webinars, interactive virtual training modules, and podcasts covering the basics of tribal court advocacy. The training series is tailored for entry legal services attorneys, either just starting out or those looking to bolster their tribal advocacy skills. At the end of this webinar, we will provide information on how to access the rest of the tribal court advocacy training series. In developing the Tribal Legal Advocacy series, we partnered with the Center of Indigenous Research and Justice, CIRJ, located in Olympia, Washington. Our presenter today is Ron Whitener, the president of CIRJ. CIRJ provides public defense services to tribes in Western Washington and training support to tribal public defenders nationwide. Before founding CIRJ, Ron previously was the founder and director of the Tribal Court Public Defense Clinic at the University of Washington Law School, and he continues to serve as an affiliate professor at UW. In 2011, Ron was named a champion of change by President Barack Obama for his work supporting and encouraging public defense in tribal courts. Ron was appointed the chief judge for the Chehalis tribes for 4 years and also for the TLOA tribes for 6 years. Ron retired from the TLOA bench in 2020 and currently consults with tribes across the US on tribal justice system development through the Whitener Group, a consulting company Ron formed with his brother and niece in 2009. Ron is a member of the Squaxin Island tribe of Washington State and continues to be active in his tribal community through commercial treaty fishing and serving on tribal committees and commissions. In today's webinar, Tribal Law and Order Act, Enhanced Sentencing, and Violence Against Women Act, Special Domestic Violence Jurisdiction, Constitutional Standards for Tribal Court Judges, we will give an overview of the standards required for judges under TLOA and VAWA. Thank you so much for joining us today, Ron.
Thanks for having me. Okay, so it's a big title, but basically what we're going to be talking about is some of the standards that are in both the Tribal Law and Order Act and the Violence Against Women Act for tribal court judges who are going to hear cases that fall under either of those statutes. And we're going to discuss those two statutes, and then we're going to also discuss the standards that are out there for determining whether or not a tribal court judge meets the standards required by those acts. So we'll start with the older act. The Tribal Law and Order Act was passed in 2010, and it's a big act and it deals with a lot of things, and you can look at another webinar that deals with all of the minutia of the Tribal Law and Order Act. But here we're just dealing with the issues related to the judges. And so the Tribal Law and Order Act, one of the things that it did was it amended the Indian Civil Rights Act, which prior to Tribal Law and Order Act only allowed tribes to prosecute crimes where the maximum sentence was a year or less. They could prosecute a murder, but the fine and the penalty and the incarceration could only be a year or a $5,000 fine. TLOA amended the Indian Civil Rights Act, and it created a two-tier. If a crime is 1 year or less and you're not going to incarcerate someone for more than a year, then they don't have to be provided an attorney and you don't have to meet the other standards that we're going to talk about. But if they're going to be charged with a crime that could carry a sentence of more than a year, or if the court wants to stack sentences and run them consecutively to where they are more than a year in length amongst all of them, then you have to meet the standards for TLOA before you can do that. And so it amended it to allow up to 3 years per crime and up to a $15,000 fine per crime. And then you can sentence consecutively for more than a year, but no more than 9 years total. And it created protections as well for if the tribe wanted to do that. First, the tribe would have to provide effective assistance of counsel at the tribe's expense if the defendant is indigent. So that the person has to be provided an attorney if they're under a certain income level. The defense counsel must be licensed in a jurisdiction with licensing standards, ensuring competency and with rules of professional responsibility. All of the criminal laws that the tribe has and all of its rules of evidence and all of its procedural rules related to criminal laws have to be publicly available. So they have to be easily accessed by anybody that's involved in the case. The tribe has to maintain a record of proceedings, so it needs to record at least the proceedings, and so that if it goes to an appeal or if it goes to a habeas corpus in federal court, that those courts have a record that they can listen to and hear what happened. And then the presiding judge must have, quote, sufficient law training for a criminal proceeding and is licensed to practice law by any jurisdiction in the United States. So we see this standard being applied for tribes. So we're going to look at what this means. After the Tribal Law and Order Act, though, the Congress then passed the Violence Against Women Act reauthorization. Within that reauthorization, it created, it recognized tribal ability to prosecute certain non-Indians who committed certain crimes on the reservation. And it's important to see how it did it. So it didn't say that they didn't delegate to tribes authority to prosecute non-Indians. Under the Oliphant case, Oliphant v. Suquamish tribe, the United States Supreme Court had found in the late 70s that a tribe does not have the authority to prosecute non-Indians at all. They created sort of a bright line test. The VAWA reauthorization said that no, we Congress recognize that tribes have the inherent authority to prosecute these very narrow sets of crimes that we're stating in the statute. So it's an interesting case because it's not delegating authority to the tribe, it's recognizing tribal inherent authority to do this very specific kind of prosecution. But if a tribe is going to exercise VAWA, special domestic violence jurisdiction over non-Indians, then it has to have in place the requirements of TLOA. So all of the things related to indigent defense counsel, effective assistance of counsel, public laws, and recording of proceedings, and a judge that meets constitutional standards. You also have the requirement that the defendant has to reside in Indian country of the tribe that's prosecuting, or the defendant is employed in the Indian country of the tribe prosecuting, or the defendant is a spouse, intimate partner, or dating partner of a member of the tribe or an Indian who resides in the Indian country of the tribe. So it creates this very narrow situation where the tribe can prosecute it. But when it does it, then all of these protections are put in place. It creates two different standards, though, in the case between the defense attorney and the judge licensed to practice. So the defense attorney has to be licensed to practice law by any jurisdiction in the United States that applies appropriate professional licensing standards and effectively ensures the competence and professional responsibility of its licensed attorneys. Under TLOA, under VAWA and TLOA, the judge, though, has to be licensed to practice law by any jurisdiction in the United States. So it's a much smaller statement. It doesn't have all of this other stuff about it. So it's a little more ambiguous than the statutory language for the defense attorney. So when we look at this, then what does this mean? You have to have sufficient legal training and you have to have a license to practice. And so what are the state requirements for judges? Because TLOA doesn't provide us any guidance, really. It doesn't define all of these things in terms of sufficient legal training and licensed to practice, we have to kind of look to the states to see what that constitutional standard is for judges. And what we see is that, especially that license to practice, that the Tribal Law and Order Act is more restrictive for tribes than it is for states. So let's take a look at some of the states. So let's look at Michigan. So in Michigan, you do have to be licensed to practice to be able to preside over criminal proceedings. You have to be licensed to practice law in Michigan with a Juris Doctor degree from any accredited U.S. law school and have passed a Michigan bar exam. Sufficient legal training to be able to preside over criminal cases. You have to have been admitted to practice for at least 5 years. You can't be appointed after the age of 70, but it doesn't really require any courtroom experience. You have to be admitted to practice for a certain number of years, but it doesn't require that that practice has to be criminal practice, just any kind of practice. So Michigan's fairly restrictive. Alaska is more forgiving for who can practice in its courts. So they have two different standards, district court and the magistrate. For the district court, the judge has to be at least 21 years old. They need to have been a United States and Alaska citizen and resident for at least 5 years immediately preceding their appointment as a district court judge. And then they need 3 years at least active practice immediately preceding the appointment, or they need to have served 7 years as a magistrate. Then you've got the magistrates. And in Alaska, a lot of the work is done by magistrates. We have way more magistrates in Alaska than there are district court judges. The district court judges will be in the hubs, what Alaska often calls hub cities, like Fairbanks, Anchorage, Bethel, Dillingham, all of these different places. And but then in all the more rural areas, what they'll have is magistrates who are handling a lot of the cases. And so there's many more magistrates than there are judges. The magistrates have to be at least 21 years old and a citizen of the United States and Alaska. Their residency requirement is less. They have to be a resident of Alaska for at least 6 months immediately preceding their appointment. The Alaska Supreme Court has the ability to set other qualifications. They can issue summonses, warrants, they can preside over felony preliminary hearings, and then they can hear criminal trials if the defendant agrees. So they have sort of a subset of what they can do in the criminal area than the district court judges. For sufficient legal training for a district court judge, again, you have to be admitted to the Alaska State Bar, meaning you have to have a law degree and have passed the Alaska bar exam. But for the magistrate court, there's no requirement for you to be admitted to a state bar, and there's no requirement that you have attended law school. Many of the magistrates in Alaska are not law trained. I've run across a lot of them who, some of them prior law enforcement, some of them are held master's degrees in various things. But once in a while, you'll have a magistrate that's law trained, but often more likely than not, they are not law trained in Alaska. For Arizona, you have to be licensed to practice, but municipal misdemeanor criminal cases do not require a law degree. So you can be appointed to hear a specific, smaller criminal cases without having a law degree. The justice of the peace, misdemeanor criminal cases may not also require a law degree, a different status of criminal cases. For sufficient legal training, for felony cases, the judge has to be licensed to practice, but again, no minimum number of years required and no requirement of actually practicing criminal law in the courtroom to be able to preside over cases. So we see a more lax standard, for instance, in Michigan, in Arizona. And what we see is just a lot of the places don't require you to be an attorney to preside over criminal cases in some form. This is a list of, I don't think I did a comprehensive look at all 50 states, but looking at a lot of the states that have sort of issues of note, these are all states that allow non-attorneys to preside over criminal cases to some degree, perhaps not felonies, but in some form they can preside over criminal matters without having to be licensed to practice, without having to pass a bar exam or have graduated from a accredited law school. So when we look at that and we look at the Tribal Law and Order Act, we see that the Tribal Law and Order Act for tribes, it requires the judges and tribes to have more training than the states require. So some of the practicalities though that we need to consider though is that it's a little bit easier for the state to be able to take somebody who's a non-attorney and turn them into a criminal judge. First of all, states tend to have pretty robust judicial training programs. You know, a lot of times what you see in states is judges have to hear all kinds of cases. They don't get to say, well, you know, I practiced criminal law because I was a prosecutor or I was a public defender, so I'm going to only hear criminal law cases. They don't have that luxury. If they are appointed as a judge or they're elected as a judge, then they have to be able to preside over the whole gamut of things that the judges do. All civil cases, all criminal cases. They may rotate into something they're more comfortable in the beginning, but they have the ability to be trained to be able to hear probate cases, even though they've never practiced probate cases, or to hear torts cases without ever having practiced tort law, right? So these state judicial training programs are in place in almost every state. And for those states that use non-attorneys, you can put these non-licensed judges into these training programs and train them on a very specific kind of case. So if they're only going to be handling criminal cases, then you can train them specifically on how to handle criminal cases. They're almost always all supervised by a judge with more experience as well. The other thing is that the states have consistent judicial codes of conduct. Not every tribe has a judicial code of conduct, or it has a very brief or narrow set of things. Usually, often you'll see tribal codes that just deal with conflicts of interest that don't deal with other things. But the states will have their rules for judicial conduct, and those non-judges can be rolled into that. And then the states also have mentorship systems for lay judges. They have, you know, people with more experience in the system that are applying the law. We unfortunately don't have that as much at tribes. A lot of tribes have a lot of judges who are very experienced that are there that can mentor new judges that are coming into the system. But a lot of tribes only have one judge. And when that judge leaves, you have to bring in a new judge, and that judge may never have heard cases at that tribe. And that tribe may be very rural. Or you could have a judge who is, you know, non-attorney because there isn't any attorneys in anywhere close to the tribe. And so, you know, for instance, Warm Springs tribe is a very large tribe in Oregon. They have no attorneys who are acting as prosecutors and defenders, but it's because there just isn't any attorneys that live anywhere close. And so a lot of tribes have to use lay advocates and lay judges for their systems. So we don't have these training systems. Certainly the National Judicial College has the Tribal Judicial College. It does some things, but usually you have to go to Reno, spend a week or 2 weeks. It can be very difficult. And it's also, again, not tailored to that specific tribe. So those programs tend to be much more general, whereas the state programs are training them on how to preside over cases under that state's laws. So most tribes, when they're looking at exercising enhanced sentencing or special domestic violence jurisdiction, most of what they do is they play it safe. They don't use lay judges. They'll use a judge, if they're really conservative, a judge that is a member of a state bar association that's either an active status, or most state bar associations have a status called judicial status, where when you become a judge, you essentially go out of active status, meaning that you can't represent clients while you're a judge, but you can switch back to active status if you ever leave the bench. And so tribes will often require that their judges be a member in good standing of a state bar in either active or judicial status. And that way, and then if they're hearing criminal cases, tribes will also often require part of their experience to have practiced criminal law if they're going to hear these cases. We see that if a tribe is able to do it, they will try to get somebody that has some criminal experience who's going to preside over those cases. One of the things that we sometimes see is tribes having judges, often they'll have lay judges for everything else, But then when they have a special domestic violence jurisdiction case or they have an enhanced sentence case, then they have a pro tem judge who doesn't sit on all cases, but is a judge that is specifically for these cases, that is a licensed attorney that practices criminal law, who will then drop in to hear just those cases that are either enhanced sentences or a special domestic violence jurisdiction case. So that's really how the tribes have dealt with it. So if the tribe is using a judge for these TLOA cases, almost every situation I've seen is that they've required the judge to be a member of a state bar association. So those are the standards for judges under TLOA and the VAWA reauthorization. Are there any questions?
Hi, Ron. We have a question for the smaller tribes looking to have enhanced sentencing. You mentioned hiring a pro tem judge. Do you know how those smaller tribes might initiate that sort of having a judge come in just on the case-by-case basis?
Well, they would just need to find someone that can do it. I mean, it's more expensive because if you're a, if they're a pro tem, unless they're from the local area, then they're going to be coming in to do it. So you're going to have to pay more and you have to find somebody that does it, but you can find somebody fairly easily. Most bar associations have divisions so that people who practice criminal law will be in the criminal like the criminal section of the bar association. So you can go to those websites for the state bar associations and see who's in the criminal section and who is local. You could talk to people in the public defender's office or the prosecutor's office that's closest to the tribe to get recommendations of people that you are experienced that they think would be good judges. Often there are judges, judges do retire. We've seen tribes hire retired state court judges to sit as judges in the tribal court. Or look for like prosecutors who have gone out of being a prosecutor and into private practice, and then asking them if they would come and serve as a judge for these cases. Sometimes judges will share from other tribes. So if a tribe that isn't too far away from another tribe has a judge who is criminally experienced and is an accredited member of a bar association, they can appoint that other tribe's judge as their pro tem and bring that judge over when they hear those cases. I mean, those are the main models that we've seen for tribes to be able to access these pro tem judges for these specific appointments.
Thank you. And you mentioned that there's more training for tribes. For tribal judges than what the state requires.
Oh, the other way around. There's more training for state court judges than tribal judges. There's
more training for state judges than the tribes require. And it's more strict, it seems like, the rules for judges for the tribes and the states. Do you know, what the reasoning was behind that when they drafted the, the rules?
Oh, I see what you're saying. You mean that the ability to sit as a judge on a criminal matter in the state is less restrictive than TLOA for tribes. Mm-hmm. Okay. My guess is that because the fact that there isn't a robust system like the state has to take somebody who has never practiced criminal law and run them essentially through a judicial boot camp to train them on how to do it. And so I think what the Congress sort of decided was, well, if we don't make it to where they have to at least be a member of a bar association, and then we're just going to end up seeing really inexperienced judges hearing these cases because they don't have access to some sort of specialized training for lay judges that the states have. So I think they decided, let's just be more protective, knowing that there isn't a system to train tribal court judges like there are systems to train state court judges, and just say that tribal court judges who want to sit on these cases have to be, members of a licensing association and have experience. And again, none of those, I haven't seen any cases that have tested it, right? So in terms of, a sufficient experience, someone could make an appeal out of a court that they don't think their judge may be accredited by being a member of bar association, but they could say that they don't have sufficient experience under TLOA. I think that argument is weakened by the fact that the states have non-attorneys doing criminal, but it could be an appeal issue, but I haven't seen anybody that's appealed that out of it. So my guess is that's why Congress made it more restrictive for tribes and states.
Thank you. So that was all of our questions, and we wanted to thank Ron for presenting today. If you have any questions about this webinar, you can email us at info@NAICJA.org. You can find this webinar and other materials, the rest of the Tribal Legal Advocacy series, at www.naija.org, and through links on our social media on Facebook and Instagram. We want to thank you so much for joining us today. Thank you.